This is Jason Lindamood with the Lindamood Law Firm, and today I'd like to talk about two documents that we're going to want to make sure that we have when it comes to our estate planning. The first one is going to be a medical power of attorney, and the second one is essentially going to go hand in hand with the medical power of attorney, and it's called a HIPAA authorization. So let's take both of these one at a time. Let's first talk about the medical power of attorney. Now, similar to having a durable power of attorney that appoints someone to handle our financial decisions in case we weren't able to, a medical power of attorney allows us to designate another individual, whether it be our spouse, whether it be one of our adult children, or even someone not biologically related to us, yet we trust implicitly, to make medical decisions on our behalf if we were to ever to become physically or mentally incapacitated. In other words, if I'm unable to make medical decisions for myself because I'm unconscious or in a coma, or if I was in a car wreck, something really bad, then the person that I've named as my agent in my medical power of attorney would essentially step into my shoes and determine which healthcare decisions needed to be made on my behalf. Fairly simple, fairly straightforward, really important document for us to have as adults in our estate planning toolbox. Now, the second document is the HIPAA authorization. And again, this goes hand in hand with the medical power of attorney. And most of us have probably heard of HIPAA. And it stands for Health Insurance Portability and Accountability Act. And it's designed, as you probably know, to keep our medical records private. And HIPAA hasn't been around for 50 years or 60 years. This is a relatively new law. I think it was enacted back in the mid-90s, I think 1996, if memory serves. And the good thing about HIPAA is that it makes it more difficult to acquire medical records, which can be a tremendous benefit for our privacy. And I don't know about you, but things become less and less private as the days, weeks, and months and years go by, it seems like, right? Especially in today's climate. So I'm big on privacy, but a HIPAA authorization has some huge benefits because the privacy that we are afforded with the HIPAA laws may have the unintended consequence of making it more complicated for our loved ones or whomever we appoint to gather our medical records from one provider in order to give our current provider, for instance, the hospital where we're at, if something bad were to happen, again, car wreck, coma, things of that nature, to give that person a more complete overall look at our health history in terms of, we're talking about the doctor who is now treating us. If we were in a situation where we're, again, incapacitated and these records are both important and needed. The HIPAA authorization gives our appointed agent the ability to essentially cut through the red tape and relieves our previous medical providers from liability under federal HIPAA laws, while at the same time providing our current doctors, once again, information that may help to inform them on how we need to be medically treated depending on what our condition is at that moment. So you can see how these two documents have a great deal of importance and how they can work in conjunction with one another. So, in summary, those are two important documents that we need to think about as we are putting together our estate plan. You guys already know this, but remember, a will, a last will and testament, comes into play once we're dead. And if we're incapacitated, meaning we're alive, but we're in a hospital, we are in a coma, we've been in a car wreck, we are unconscious. We are still living, our heart is still beating. We still have brain activity, but we are incapacitated for all intents and purposes. So if we are incapacitated, the language in our will has no current effect. And you guys probably already know this, but I think it's important to drill that point home. So to protect against being alive yet incapacitated, we'll want to have additional documents such as these on hand just in case, because these are things very few of us ever really plan for, right? But it's similar to Murphy's Law in that something's going to happen or when something does happen, it will happen typically at the most inopportune time, right? And that's something that we want to prepare for ahead of time, because if something does indeed happen to us, we'll be glad we took the necessary steps to make things easier on both us, as well as our family, and as well as our loved ones. That's it for today. A medical power of attorney and a HIPAA authorization. Think about adding those to your estate planning documents, and you'll be glad you did. If nothing else, it'll fall under that broad category of it can't hurt to have them, just in case, right? So once again, this is Jason Lindamood with the Lindamood Law Firm. If you found this information helpful and you are in a position where you can hit a like button, or maybe share it with someone that you think would find it interesting, or even if you're able to leave a comment on wherever you're viewing this video on, whether it's YouTube, whether it's LinkedIn, whether it's the website, any place you're viewing this, if you're in a position to either like it, share it, or comment, I always appreciate those. I really do. And if you have any estate planning questions, if you have any will questions, or if you have any probate questions, feel free to contact me by going to estateplaninfo.com. That's estateplaninfo.com. That'll take you to the firm's website, which is lindamoodlawfirm.com. And from there, you can schedule a time for you and I to talk. So thank you for your time. As always, thank you for watching, and I'll talk to you again soon.